Merci beaucoup, Madame la Présidente. Merci aux organisatrices pour le très bel accueil qui nous a été réservé dans ce centre, dans cette université qu'on associe si volontiers aux relations extérieures de l'Union. Je vais faire ma présentation en anglais. EU FTAs create joint committees as bilateral executive bodies comprising representatives of both parties in charge of supervising and facilitating the implementation and application of those agreements. These committees are assisted by specialized committees, which are sectoral committees which prepare general decisions and other action by the joint committee. And these all set of committees are conceived as a system to make these agreements living instruments, that's the expression which is often used, which can adapt to social and political evolutions. Entities of this kind are established by all EU FTAs and actually also by other kinds of EU bilateral agreements. For example, next Tuesday, there will be the 8th EU-Montenegro Stabilization and Association Council, which shows that actually this kind of committee is used far beyond FTAs. I won't dwell in detail on TTIP issues. I will do it just a bit, but there would be probably some points which could revert to in the general discussion concerning specificities of the general institutional structure of TTIP. But for the presentation, I'd like to focus more precisely on the powers of the Joint Committee in TTIP as an example of joint committees of all EU FTAs, and the way that in which EU institutional law deals, of course, with challenges created by these powers. Of course, this is a matter of concern for all interested actors, and just to give a recent example, in February, as the European Parliament debated before consenting to the conclusion of CETA, the extent of powers of the CETA Joint Committee was precisely one of the most passionately debated issues. I would like to address three sets of issues. First of all, I would like to analyze briefly the functions and powers of these joint committees, starting from the example of TTIP, so from the point of view of the international agreements. Secondly, I'd like to address some issues on the EU primary law framework, dealing with those functions and powers. And thirdly, the issue of coordination between the EU party, in particular between the EU and member states, so beyond primary law. As we will see, this is mainly an issue for interinstitutional agreements. So let's start from the first point, functions and powers of the Joint Committee. As I said, the general function of this committee and of these committees in FTAs is to supervise and facilitate the implementation and the application of the agreements. Even if these committees adopt their own rules of procedure, the functioning is based on mutual agreement, mutual consent of both parties which compose the Joint Committee. Their functions range from very soft law making to real hard law making. It's, as you will see, it's not always easy to distinguish these two aspects, but I will try to do so in two steps. So first of all, these committees have soft law making powers. First of all, generally discussion. So these entities are supposed to provide a forum for discussion, not only between the parties, and that's one of the most interesting points on which there was some evolution in TTIP as compared to other EU FTAs, but also with the civil society. This might be interesting in the sense that this could foster some mild form of supranational legitimacy, but of course from the legal point of view, language used in the agreement is non-binding, so the terms used are supervision, facilitation, guidance, and several synonyms. Secondly, another soft lawmaking function is of these committees is dispute prevention. So discussion to avoid real dispute settlement, not only referred to state-to-state dispute settlement or ISDS dispute settlement, but also conciliation mediation, which are themselves separated from the activity of the Joint Committee. And then these committees also have a power of recommendation. And that's where we start to see some effects, some legal effects, which are typical effects of soft law. For example, one could imagine that this recommendation can be used for the interpretation of the agreement as subsequent practice of the parties, and even create some presumption in dispute settlements. For example, if practice is recommended by the Joint Committee, it can be prima facie considered to be licit. Nonetheless, it is clear that the refusal to comply with the recommendation of the Joint Committee should not entail significant legal consequences, especially for dispute settlement. Where implication can be a bit more far-reaching are it is issues of dispute settlement overview. Indeed, the Joint Committee has important functions of overview, in particular for ISDS, actually also for state-to-state dispute settlement, but that's more interesting for ISDS. For example, the Joint Committee appoints the members of tribunals, of the tribunal and of the appeal tribunal, in, as it was conceived in TTIP, in CETA of the appellate tribunal, and decides on some administrative issues such as fees, or even the number of members of the appellate tribunal in CETA, which can be increased by the Joint Committee itself. In CETA, this was not to be found in TTIP at draft, but in CETA, there's even a sophisticated filtering mechanism which applies to some disputes in particular, which are those relating to prudential regulation in financial services. Most importantly, the Joint Committee also has the power to adopt interpretation of the agreement, which are binding on the parties and which are binding for dispute settlement bodies, including ISDS bodies. And this corresponds to a more general power of interpretation. This power of interpretation is actually standard in trade law and is becoming more and more used also in international law. Of course, it is a useful and powerful tool for parties not to lose control over agreement interpretation. But that's where we shift slightly towards hard lawmaking, because there's also a risk of potential hard lawmaking in disguise. The boundary between interpretation, decision, and treaty amendments are not always clear. The Commission had considered precising those issues, those distinctions, in future FTAs, but this was not done either in CETA or in TTIP. So let's see what kind of real hard lawmaking powers these joint committees really have. First of all, it is important to underline that, in principle, decisions can only be adopted when the agreement so provides. But actually, there is a sort of general clause, which is a quite open-ended clause, which is quite far-reaching, both in TTIP drafts and in CETA, like in all other EU FTAs. The joint committees can also, I quote, take such other action in the exercise of its function as the parties may agree. So this is also standard language, and this clause has never raised specific issues, but it shows that there's somehow a potential of nullifying or overcoming all efforts to define precisely the decision powers of the Joint Committee in other clauses of the agreement. Are these decisions binding? That's an issue which was raised also in Bundesverfassungsgerichts's proceeding concerning CETA. If I sum up this issue, we can say that, first of all, decisions need to be approved by both parties. So there's no risk of autonomous functioning or autonomous will of this committee. This is not an international organization. And on the other hand, internal requirements and procedures need to be respected concerning the way these decisions are done. So this could be particularly important for ultra-virus actions by EU institutions, so cases in which EU institutions don't comply with EU law on the way in which they're supposed to participate in the activity of this committee. However, once decisions are regularly adopted, they are indeed binding and they must be implemented. These committees also have powers of amendments, and there is agreement amendment, and there is some variation in TTIP drafts and in CETA. We can say that if you take, for example, CETA, the power of amendment was quite broad, and indeed that's why it was broadly discussed in Bundesverfassungsgerichts's proceeding, because it concerned all protocols and annexes unless this was excluded by the agreement. So it was a sort of negative list approach to this issue of amendment, unlike, for example, in TTIP drafts. It is true that most sensitive protocols and annex were excluded from this power of amendment, but as we have seen for geographical indication, which were not included in the negative list for amendments, it might be difficult to determine exactly what is most sensitive in this respect. So let's try to understand how, given these powers, EU primary law applies to the activity of these committees. There are three questions I would like to address. And first of all, are there any limits, constitutional limits, to the power to participate in those committees and even to establish them, even in fields of EU competence? Then briefly, a couple of issues of competence, which actually were already covered yesterday, and then a couple of specific procedural rules, which for some of them have already been covered in other contributions today and yesterday. So the first question is, are there any limits, not to competence, but to the conditions of establishment of those bodies? Are there intrinsic, inherent limits in EU constitutional law? Is there something that EU legislature may not want in concluding EU FTA? This is quite a classic problem. We have seen it already this morning. On the one hand, we have the objective of flexibility in international relations, so the fact that life must still be made possible, as we've heard this morning. But on the other hand, there's of course a need not to circumvent the normal functioning of EU institutions. So that's very much an issue of autonomy of EU law. So, as recalled in Opinion 215, the competence of the European Union to enter international agreements does include competence, power, to couple those commitments with institutional provisions. And indeed, in the EU case law, there's not very much that could lead to think that there are extensive limits to the power to participate in and to establish even that kind of committee. Overall, one must say that this is perceived as a problem which is much less serious than, for example, the issue of international judicial control, so the power not of the legislature, for example, but of the European Court of Justice. What are the possible effects of binding decision and amendments? They can become part of the EU legal order. The European Court of Justice has already stated that for several binding decisions of committees or bodies established by international agreements. So they are binding not only under international law, but also under EU law. Given those potential effects, are there any conditions for the integration in the EU legal order? I would say that there are essentially two conditions that stem from the ECJ's case law. First of all, there is a procedural condition, not only in the international agreement, but also in EU law. The procedure for adopting those decisions must be respected from the point of view of EU law. Then there is some substantial limits or conditions to the effects of this decision in EU law. In the Savins case, in 1990, the courts underlined that this kind of decision must be directly linked to the agreement which they implement. So one could generalize this dictum as a condition, as an ultra-virus requirement, in the sense that this decision must be lawful under the agreement. They must not be unlawful under the international agreements. And secondly, one could imagine, even if there is no specific case law on that, that there is also an EU law ultra-virus requirement in the sense that no act can be adopted by EU institution beyond their powers. The court has explored this field of these issues in the France against Commission cases in 2004 and before that in 1994. But the exact implications are not totally clear, and that's precisely a point where theoretic potential for development is there, and of course it's also an issue of judicial policy. Concerning competence, actually, we have already said most relevant things yesterday. These kind of provisions are ancillary in nature, and the consequence for this kind of agreement is that the coverage by EU, at least by EU exclusive competence, is not total for institutional clauses. Concerning the procedural framework in EU primary law, there are two relevant articles which whose use could be generalized to, notably to protect interinstitutional balance and member states' powers. Article 218, paragraph 9 has been discussed a bit this morning. I'd like to say just a word about Article 218, paragraph 7, which has not been mentioned yet. That is the paragraph under which the Council may authorize the negotiator to approve, on the Union's behalf, modification of the agreement, and also set conditions for that. So it's a provision which can be used at the moment of conclusion of the agreement, and which can also be used to set conditions for the conclusion of the agreements. This provision has been seldom used, but again, it could be used more generally to develop conditions in favor of interinstitutional balance or other issues that the EU legislature might wish to protect. So, as you can see, there is some uncertainty about the content, of the precise content and the precise use of relevant provision of primary law, and of course this raises the issue of coordination within the EU party beyond EU primary law, especially by interinstitutional agreements. That's mainly an issue of concern for member states' representation. Of course, there's also an issue of protection of the European Parliament, which will be covered soon. But I would like to underline that some solutions have been developed or are developed for CETA, which could be used for other FTAs, in the form of interinstitutional agreements, or anyway declaration and statements by member states, by the Commission and by the Council. And the general idea is that while member states do not need the formal membership in the joint committee or in other committees established by these agreements, what is needed is that their position must be clearly expressed and respected in fields that go beyond EU competence. And this implies agreement, unanimity, on amendments, for example, as a requirement in the Bundesverfassungsgericht decision of October, and with some variation according to statements and declaration annexed to CETA Council decision, for all decisions, more broadly, that go beyond EU competence. So, in conclusion, we have seen that this is very much an issue of importance for EU FTAs, and that the powers of these committees arise quite complex issues from the point of view of EU law. There's quite a lot of uncertainty, and we might discover at the same time that some practices which are well established in EU FTAs are actually unlawful, or anyways at the limit of lawfulness from the point of view of international law, institutional law. And or we could also discover that new and original solution can be developed in the next few years or months. So practice, and in case there is any case law, will be very interesting to follow, and that is something that we will all do certainly in the next few months. Thank you very much for your attention.